Today we are going to study the first topic of Indian Contract Act 1872, and the name of the topic is Nature and Kinds of Contract. First we will see the introduction part. The name of the act is Indian Contract Act 1872. This act applies to whole of India except the state of Jammu and Kashmir. So Jammu Kashmir पे ये act नहीं लगेगा. And the effective date ये 1st September 1872 से effective है. So you can see this is a very old act. Now let's see the object of this act. कोई भी act आपको पढ़ना है, if you want to study any act, it is very important that you should understand the object of that act. The object of this act is very simple. It simply allows persons to make laws for themselves. So you can say that it creates just in personam. इसका मतलब होता है कि right against the persons and not just in rem. इसका मतलब does not give, this act does not give right against things, but it gives the right against the person. Let's try to understand this concept, this object, with the help of a diagram. Suppose there is a particular thing which A is having, this person is having, and B wants to purchase this thing from A. In return, B will give him 100 rupees. Now this arrangement, A is selling a particular thing to B, and B in return is giving to A 100 rupees. This arrangement will be treated as contract between A and B. And if either of this person, either A or B, if they don't fulfill their promises, then either of the party can move to the court of law. So they can move to the court of law. Suppose A has given book to B, but B has not made the payment of 100 rupees. Then A has a right against B to get 100 rupees and he can move to the court. Similarly, if B has made a payment of 100, then B will have a right against A to get the book from A. Otherwise, B can move to the court of law. This is possible only because of the Indian Contract Act approves such type of arrangement between the person and gives the right against those persons. So we have seen that parties can enter into contract. These contracts gives rights to them. These rights are protected as per the Indian Contract Act, and either of the party can move to the court to enforce such rights against the other person. That is what we call jus in personam. That is, these rights can be enforced against the other party to the contract. Now let's see the very important part of this act, that is the definitions. Lot of time definitions are asked in the exams. So first we are going to see three definitions. First definition is contract under section 2H, agreement under section 2E, and promise under section 2B. First see the definition of contract. Section 2H says that an agreement enforceable by law is a contract. There are two parts in this definition. First, there should be an agreement, and second, such agreement should be enforceable by law. So the contract means an agreement. First, there should be an agreement, and agreement should be enforceable by law. These are the two components of the definition of contract. It means all agreement may not be contract. So see, there are so many agreements. These are agreements. Only those agreements which are enforceable by law will become contract, will be treated as contract. Now here you have to understand one thing, that only few agreements which are enforceable by law will become a contract. It means all agreement per se are not contract, only few of them are contract. Now let's see the second definition, that is agreement. Agreement is defined under section 2E of the Indian Contract Act. It says that every promise and every set of promises forming the consideration for each other is an agreement. So there should be a promise first of all for becoming an agreement. Let's try to understand the definition of agreement with an example. Suppose one person is having a book, and this book he wants to sell to B. So B is another person who want to purchase this book from A. Now A promises to give this book to B. So he is making a promise. A is making a promise that I will give this book to you. And on the other hand, B is also promising to pay 100 rupees to A in return, in consideration. That is, there are two promises. Promise number one, that is A is making a promise, I will give you this book. And promise number two, in consideration of this promise number one, that B is saying, I will pay you 100 rupees for this book. So you can see that these promises, promise number one and promise number two, forming a consideration for each other, and once both persons give these promises, it becomes an agreement. Remember, this is just an agreement. It is still not a contract. Unless until such agreement are enforceable by law, it will not become a contract. So agreement, there should be promises, that is set of promises forming consideration for each other. Now let's see the definition of promise. You have heard promise so many times, but let's see the actual definition of the promise under the Contract Act. Section 2B says, when the person to whom the proposal is made signifies his assent. Assent मैंने वो जब हाँ कर देता है उसके लिए, assent thereto, the proposal is said to be accepted. तो ऐसा मान लिया जाता है कि वो proposal accept हो गया है. And when the proposal is accepted, it becomes a promise. For example, suppose A ask B, will you marry me? He is making a proposal. Will you marry me? This person is making a proposal to B. So once B says that yes, that is, B is signifying her assent. So this proposal is accepted. So A is making a proposal, will you marry me? And B, she is saying yes. It means this proposal has been accepted by B. And once this proposal has been accepted by B, B is making a promise here. Once B accept this, it means B is making a promise, yes, I will marry you. So you can see that for a promise, there should be two things, in fact three things. There should be a proposal. So proposal should be accepted, and once it is accepted, it becomes a promise. Now let's focus on the most important section of Indian Contract Act, that is condition of enforceability. We have already seen that all agreements are not contract, only those which are enforceable by law will be treated as contract. Now section 10 clearly says that all agreement are contract, but after that it puts an if. So an agreement will be treated as a contract if they are made by free consent. So the parties to the contract are giving their consent freely. There is no pressure on the parties to give consent. Then parties must be competent to contract. It means they should not be minor or lunatic persons. So they should be competent enough to contract. Then there should be lawful consideration. Whatever you are giving and taking and giving back, there should be, the consideration should be lawful, legal. It should not be illegal consideration. And with a lawful object, the object of the contract should be legal and are not hereby expressly declared to be void. And the agreement should not be such that which is declared to be void by the law, any law. So we will see all these items into detail after a couple of minutes. Now, from this section, we can see that for an agreement to become a contract, agreement must fulfill all these conditions mentioned by section 10. So there should be a proper offer and proper acceptance with the intention to create a legal relationship. And there should be lawful consideration. Parties should have a capacity to contract. They should be competent enough to contract. There should be free consent of the parties, and there should be lawful agreement. The object should be legal and not declared to be void by any law. So now we can see that to become a contract, there should be agreement, and such agreement is enforceable by law. And what is enforceable by law? It is clearly mentioned under section 10. So section 10 will decide whether an agreement is a contract or not. Let's see the essential elements of a valid contract again and in detail. First, there should be offer and acceptance. So one party is making an offer to another and the other party is accepting it. So let's see, there is one party making an offer and the another party is accepting that offer. So this is the first condition, offer and accept. Second is mutual consent. So here both the parties are giving consent to this arrangement freely. The consent should be freely. There should not be any pressure on either party. Then it says there should be a legal obligation. So there should be intention to create a legal obligation. So what do you mean by legal obligation? Suppose A is asking B to come for a dinner, and if B does not come, A has no intention to the move to the court, right? But suppose A is saying that kindly come to my party to sing a song, and for that I will pay you 5 lakh rupees. Now, if you don't come, then my reputation will degrade it, and in that case, I will move to the court. So here there is an intention to create a legal obligation. Next thing is free consent, that we have already discussed, that there should be mutual consent. It should be free consent. There should not be any pressure. Then there should be competent parties. See, दो बच्चे अगर contract कर रहे हैं, so there will not be any contract under the Indian Contract Act because they are not competent enough to enter in. This point we will see in detail later on. Then next thing is lawful consideration. Whatever you are giving and taking back, or another thing you are taking, there should be lawful consideration. Then there should be lawful objects. The contract should have legal object. All these things we will see in detail later on. Not declared to be void. There should be some contract which are declared by the any law to be void. For example, export of rice is banned for a particular period, so you cannot export rice. So these are declared to be void in such cases. So it should not be declared to be void. There must be certain. Certain means the contract should clearly spell the terms and condition and the things. If it is not clear, it will not become, agreement will not become a contract. For example, मुझे वो चाहिए, तो वो चाहिए जब तक आप स्पेसिफाई नहीं करेंगे, वो आपका कॉन्ट्रैक्ट नहीं बनेगा. Then it must not be impossible, because law is not for foolish people. So if a person say I will bring stars, and for that you will pay me 100 rupees, so this agreement is not a contract, because nobody can bring stars from the sky. So it is impossible, and court will not waste time for such type of agreements. So this is not a contract which can be enforceable by law. So the things which you are promising must be possible things. It should not be impossible. Now let's see the classification of contracts. See, contracts can be classified on the basis of three parameters: enforceability, second, formation, and third is performance. Let's see all the three one by one. First, we will see the kinds of contract on the basis of enforceability. The first type is valid contract. This is a normal contract. A contract which is enforceable by law is a valid contract. For example, there is one person A. A want to sell his car. A want to sell his car to B for 50,000 rupees. So 50,000 rupees. A want to sell his car to B, and B accept this proposal. So this is a valid contract which can be enforceable in the court of law. Now let's see the void contract. Void, it is very important. A contract which ceases to be enforceable by law is called a void contract. Please note that initially it was a valid contract, but after some time, because of some happening of events, it ceased to be enforceable by law. Suppose A wants to marry B. So A wants to marry B. A offers to B for marriage, and B accepts this offer of marriage. But after accepting this offer, B dies. Now, initially the contract was valid, but once B is died, now there cannot be marriage with the B. So it will become void contract. Now let's see voidable contract. In voidable contract, a contract which can be terminated, which can be resigned by one of the parties to the contract, then it will be treated as voidable. This is very important type of contract, and most of the time it is asked in the exams. See, there are various circumstances. There are so many circumstances under which one or more parties to the contract get a right to terminate the contract. We will see these in detail, but for the time being, I will give one example for this. For example, we have seen that A is making a proposal to B that kindly marry me, will you marry me? And B accepts this proposal, then it is a contract. But suppose A is threatening B that if you don't marry me, then I will shoot you. And under the pressure, B is agreeing to this proposal, then this is avoidable because B's consent was not free consent, it was under pressure. So B will have a right to resign this contract later on. So this is one circumstances I have explained that when a contract is it will be treated as voidable contract. There are other circumstances also we will see later on. Now let's see unenforceable contract. A contract which cannot be enforceable in the court of law due to some technical defect. That is why it is called unenforceable. It cannot be enforced in the court of law because of technical defect. For example, there are certain contract which need to be executed as per different laws on a properly stamp paper. Proper value of stamp should be affixed on the agreement, then only it will be treated as valid and enforceable in the court. So all such type of contract which are required to be in a particular form or properly stamped, if you have not executed the contract as per the requirement, it will not be enforceable in the law because of the technical defect and will be treated as unenforceable contract. Now let's see the different kinds of contracts on the basis of formation. First is express contract. So any contract which is made in writing or which is made by words of mouth, that is orally you have made the contract, writing or orally, so it is called express contract. Next is implied contract. Now you can see the word implied means it is implied by act or conduct of the parties. Here there is nothing is in writing or by word of mouth. It is just by the act or conduct of the parties we assume that there is a contract between the. For example, there is one person who goes to the coffee shop and he drinks a coffee there. He drinks a coffee there. Coffee was served and he drinks that coffee. Now by this act of this person, he is bound to pay for the coffee. It is assumed that since he is drinking the coffee, he will have to pay for the coffee. So by act we can conclude that there is a contract. So it is called implied contract. Now we will see the quasi contract. This is very important and you have to understand it properly. See, such type of contract, there is no intention of the parties to the contract to enter into a contract. It is by chance it happens. It is based on the principle of equity. Suppose there is one person A, he orders pizza from the pizza shop, and there is another person residing in the neighborhood of A. Suppose this pizza boy delivered the pizza instead of A, he delivered pizza at the house of B, and B in surprise he eat that pizza. So B was under not any intention to order the pizza and pay for the pizza, but by mistake it was delivered to B and B has eaten that pizza. Now B will be liable to pay for that pizza. Here the principle of equity comes into picture. No one can enrich himself at the expense of other. So if you have utilized anything, services or any particular thing of any other person, so you will have to pay for that, whether you had that intention to pay or not. So there are various circumstances we will see later on when we, that is the law, treat such activities or acts as a quasi contract, and the parties will be liable to pay for that. Now let's see the kinds of contract based on the performance. We can divide a contract on the basis of performance into four parts. First, see the unilateral contract. It is very important. That is a one-sided contract. It means one party has already performed his part, and it is up to the other party to perform the contract. So it is also called a contract with executed consideration. Let's see one example. Suppose there is one teacher who offers to his student that he will give a car to those student or that student who will score 100 out of 100. This is the open offer. Now, out of so many students, one student scores 100 out of 100. The moment that student scores 100 out of 100, it becomes a contract, because the moment it becomes a contract, this student has already performed his part. Now it is up to the teacher to perform his part. So this is called unilateral contract. Now let's see bilateral contract, where two-sided contract. These are two-sided contract where both parties have to perform their promises. Nobody has performed their part, so both the parties still to perform their promises. It is called bilateral contract. Now let's see executed contract. It means a contract which is completely performed by both the parties. So both the parties have performed their part, so it will be treated as executed contract. Now let's see executory contract. It means a contract where something remains to be done by one or both of the parties. It means something has already done and something still to be done. Something is left to be performed. So it is called executory contract. Now we have reached to the end of this part. I hope you must have understood all the concept of this topic. In case still if you have any doubt or query, you can call me at this number. And don't forget to revise and give test.